You're watching Newzroom Afrika. Let's get into this discussion now, and it's one of our leading stories where the state and the defense in the Senzo Meyiwa murder trial will have the last opportunity to state their case on the admissibility of alleged confession statements. This as the new and final witness of the trial within a trial in the Senzo Meyiwa murder case is expected to take the stand in Pretoria this morning. The trial hearing explosive revelations, including some shocking claims since it began last year. Let's reflect now on some of the evidence in that trial within a trial and what the ruling might actually mean. Let's speak now to Advocate Deon Poole, a legal analyst. Advocate, good morning to you and thank you for your time.
Good morning, Xoli.
Thank you so much for making time for this. Let's begin the conversation with the admissibility of confession statements in a criminal trial. How do you determine that, or how does a court determine that?
The admissibility of a confession is regulated by Section 217 of the Criminal Procedure Act, in that a confession, as we have discussed before on your show, is basically a document wherein an accused will state that he is admitting to all the elements in respect of the alleged offence. And therefore, the requirements for a confession to be admissible are extremely strict and stringent. And specifically as far as the Senzo Meyiwa case is concerned, is that there is the requirement that the requirement that's been attacked is that a confession must be freely and voluntarily made, i.e. that an accused who makes a confession must not have been subjected to any form of duress, must not have been assaulted or threatened in any way, must not have been said that he will be paid a certain amount of money if he confesses, he must not have been influenced in any way. And those are the issues that are raised in part between the defense in respect of Mr. Sibiya and Mr. Ntanzi.
And I'm glad that you mentioned all of these elements, Advocate, that these confessions must be made freely and voluntarily without any sort of inducement. The claims from the accused are that they were assaulted in order to make these confessions, and there is an amount of 3 million rand that was stated by the lawyer representing one of the accused, and that 3 million was allegedly to implicate other people among the 5 now that are before court. At which point does the court reject the admissibility of evidence? Is it if all of the above that we have spoken about here has not been observed or has been found to have been, in fact, true?
A trial within a trial works similar to a normal trial. If a state wants to rely on the content of a confession, the state has to prove that the requirements of the confession have been met. And in that it has been freely and voluntarily made without any undue influence, and the accused was at his sound and sober senses at the time of making that confession. Similarly, so in support of that, the state will rely on the document itself, which is completed by a magistrate. That document is rather cumbersome because there are several questions and several processes that the magistrate has to go through in order to satisfy himself that the person sitting in front of him is wanting to make a confession, whatever the type of confession is that this person intends to make. Now, one of the accused has alleged that he would be paid 3 million rand in order to implicate other people. To the extent that that evidence would be reliable is dependent on the nature of the evidence given and to what in what manner that is supported. But what is important as well is that an accused may come to court and allege that he was unduly influenced on some or other level to make a confession. That does not per se detract from the content of that confession. So the court's going to take a view on the probabilities related to the version of the accused versus what the state has produced in those circumstances, like the gentleman from the police station, I think, was to testify about the occurrence book.
Yeah.
And what was recorded in the occurrence book, because the defense is now, they are now trying to, or not trying to, they are basically wanting to determine whether the narrative that is before the court has got some veracity to it, in the sense that there is at some point in time the accused were either assaulted or unduly influenced, or whatever the story may be that is currently being relied on in order to get the confessions chucked. Mr. Ntanye has also raised the fact that his erstwhile lawyer, Dominic Ntiako, he fired him because Mr. Ntiako was wanting him to plead guilty to the murder of Senzo Meyiwa to start off with. Now, whether that is true or not true or not for the purposes of these proceedings will of course depend on all the evidence in respect of what happened, what were the surrounding circumstances at the time that both of these gentlemen were taken to a magistrate for the purposes of making this confession. And then ultimately we will either look at the document itself, in other words, what it is that the magistrate recorded in each instance. Mm-hmm. The same magistrate must not have made the confessions for both accused. They must preferably have been taken to different magistrates. And then, if need be, the magistrate himself can be called to come and answer to the questions, specifically in this instance whether Mr. Ntiako was actually present at the time that Mr. Ntanzi made his confession.
Yeah.
I find that very peculiar that would have been the case. But in the quickest way to resolve that is to call the magistrate, because he would have recorded it.
It's very interesting, Advocate Poole, that you bring up this name of Mjiako, because information has since come to light that Mr. Mjiako was in fact a police officer who has been dismissed from the service. So I don't know how that is going to color this trial within a trial. But I'm glad we're dealing with the content of the so-called confession statements, because if this, what is now taking place, the trial within the trial, the evidence that has been presented here, if the judge decides that none of what has been presented here is actually admissible for one or whatever reasons that he may decide, does that mean the entire content of the evidence that has been adduced here will not be used in the main trial?
Yes. Basically, the trial within a trial is there to determine the admissibility of the confessions. If the judge decides that for whatever reason that the requirements for the admissibility of the confession have not been met, then the evidence in respect of the confessions and how it came about and the confessions themselves will then be ruled inadmissible, and the state cannot rely on it.
But the people will not unhear what they have heard. I don't know if there is such a term. Basically, what has come out in court, such as, for example, the startling revelations about Kelly Khumalo, that's the person whom Senzo Meyiwa was in a relationship with before he died. Information has come to light suggesting that these accused, she may have been connected to them via cell phone evidence. All of that information, are you saying that it will, in all probability, be a non-factor in the main trial?
In the main trial, that evidence will have to be relayed, because the evidence in respect of the trial within a trial is only there for purposes of determining whether the confessions have met the requirements. If there is ancillary issues which have now come to light, i.e. that Ms. Khumalo may have had a prior relationship with some of the accused or one of the accused, because the suspicion, for lack of a better word, is now being created that she was instrumental in some way or another in respect of Mr. Meyiwa's death at the time. So that information is ancillary to the trial, to the main trial, to the evidence in the main trial. And if the state wants to rely on that evidence to the extent that it is admissible and that it takes their case further, and I'm saying that it is admissible, there is a concept in our law called, it was now on the tip of my tongue.
Yeah.
But it's evidence that is basically ancillary to the main evidence in a trial. Now, if you want to lead that evidence, you first of all have to provide the court with a basis why this evidence is relevant to the proceedings at hand, the main proceedings, and to what extent it may or may not advance the state's case. Now, the court can make a ruling on that as well and say, you know, this is so far removed in time and substance from what you are actually claiming in the charge sheet and in the evidence before this court that I am not going to listen to it, and I'm going to regard it as inadmissible for now. And the court doesn't want, and the court will say it's going to be irrelevant and simply just move on. Alternatively, the evidence can be presented to the extent that it furthers the state's case or creates an environment in which the accused version of events is placed under serious doubt.
Yeah.
This information concerning Ms. Khumalo must also perhaps be seen in the context of the fact that Mr. Meyiwa was murdered in 2014. The gentlemen that are presently before the court were only arrested about 5 or 6 years later.
June 2020.
To a large extent, the evidence that the state is relying on, except for these confessions, is evidence of a circumstantial nature. The moment, in my view, as I understand it, the moment the confessions are kept, there's going to be very little evidence left for the state to rely on to the extent that there is a balance, that there's proof beyond a reasonable doubt that is being created before the court. And I think that, or not, at least I don't think, but it's clear to me that it is important for the defense to interrogate the integrity of the processes as well as the confessions that have been relied on by the state in this case. And I have 1 or 2 questions in respect of how these confessions came about, but I'm now not going to comment on something that is currently in the public domain and in court itself. But I can understand why this whole issue has come up. I'm just not sure how Mr. Ntiako fits into it, but be that as it may, there might be a problem with the confessions as far as the admissibility is concerned.